Well, thank you. My name is Jeff Homestead. I'm a partner with Bracewell, formerly Bracewell and Giuliani, and I have the honor of moderating this panel. I've spent virtually all of my professional career working on issues related to the Clean Air Act, and I must say I've been looking forward to this panel this morning. As most of you probably know, litigation over the Clean Air Act has given us some of the most important and controversial cases that we have, not only in environmental law, but even in administrative law as a whole. Anybody who practices administrative law, in fact, anybody who's gone to law school in the last 30 years has probably heard of the Chevron Doctrine, which comes from the case of Chevron versus EPA. But many people don't remember that actually is a Clean Air Act case. In addition, most of the most important administrative law cases to come out of the Supreme Court in the last decade have also involved the Clean Air Act, going back to Massachusetts versus EPA, more recently the UARD case, the MATS case, and some of you may be following another case that's making its way probably towards the to the Supreme Court dealing with the Clean Power Plan, and I think we'll have a chance this morning to talk about most of these cases. I am not going to give long, flowery introductions to each of our panelists. We have a very distinguished group of law professors here. And we also have Don Elliott. He was looking at me right here in the Skype screen, but I've known Don for many years. We're happy to have all four of them. I believe that the order that has been agreed upon is that first we will have the opportunity to hear from Nathan, is that right?
That's right.
Who formerly at RFF, now at South Carolina Law School. Next, I think we have Jonathan Adler, whom I know most of you know, who's written in this area for many years from Case Western. I think third, we'll hear from Bill Busby, now at Georgetown Law School, and finally from Edon Elliott, who, and I guess I should have started out by saying we'll be hearing from him through Skype. So we've reserved the cleanup spot for him. My main role, I think, is to make sure no one goes over their allotted time. So that will be easy with Don. I can just unplug the feed. Everyone else, I'll try to get their attention and give you maybe a 1-minute warning when you're getting near to your time. So thank you.
Sure. Thanks everybody for coming today. Thanks to George Mason, Naomi, and Jonathan for the invitation. I'm going to try to keep my comments brief. I've talked about this paper a few times, and every time I do it, I feel like I have to build a castle just to tear it down. But I think I've gotten a little bit better at talking about it, so my apologies to the extent that it's still complicated. And if it makes you feel any better, it would have been worse had you heard me talk about it before. So this is a paper about something called the Major Questions Doctrine, which is an exception to the broader Chevron Doctrine that Jeff Homestead just told you about. Remember, Chevron works in some range of cases to take judicial discretion away from judges, or rather interpretive discretion, and give it to agencies. So our normal model is, well, who decides what the law says? Judges do. Marbury versus Madison, it's the province of the Judicial Department to decide what the law is. There's an exception to that general rule in the Chevron context. That is, when an agency is acting, let's say EPA is regulating a class of pollutants, or IRS is issuing a minor rulemaking to make tax credits available to unfederal exchanges for certain users of health benefits under Obamacare, et cetera. Agency is doing something under its enabling act, under its statute. Whether a question arises whether that act is within the authority granted by that statute. Marbury would tell us, well, judges get to decide what the law is, but Chevron says no, at least within some band of reasonableness. When the statute is ambiguous, we defer to the agency, and that there's two parts there. We have to decide the statute is ambiguous, and that the agency is acting in some kind of reasonableness zone. If so, then judges will defer to the agency. We have a zone, therefore, where judges are not deciding what the answer is, or what the legal answer is. There are some exceptions to the Chevron Doctrine, as most of you know. I won't get into many of them in detail, but one of them that I will talk about is something called the Major Questions Exception. It simply boils down to this, if we can take the Supreme Court as their explanation of the doctrine at its face value, which is in extraordinary cases. And extraordinary cases isn't defined, at least not precisely. In extraordinary cases, Chevron doesn't apply. Judges once again decide what the law is. Cass Sunstein has called Chevron a counter-Marbury for the administrative state. This is, in a sense, Major Questions Doctrine is a counter-Marbury, so we're 3 levels deep. But essentially, that third level takes us back to the level we were originally at. It doesn't hopefully add a lot more complexity. Major questions doctrine comes out of a couple of cases. I call them in the paper old cases. I realize that's not really accurate. They're like late 90s, early 2000s cases. MCI versus AT&T, the FCC tries to exempt certain long-distance companies from rate review. FDA versus Brown and Williams is a little bit more well-known case. The FDA tries to regulate tobacco as a drug. In both cases, it's unclear whether the enabling statute gives the gives the agency the authority to act or not act. In this case, in both examples, Supreme Court says this is a big deal, this is an extraordinary case, we're going to change the rules in some way and not use the standard Chevron framework. Those two cases come out, then for about 10 years or so, the doctrine doesn't get used at all. Some scholars declare it dead. In the paper I talk about, well, maybe it's kind of working in the background the whole time. It's also only about extraordinary cases, so you think those would be relatively rare. Nevertheless, it receives a lot less attention for a while. Comes back in very clear, probably its most clear form ever in King v. Burwell, the Obamacare case last year. Chief Justice writes his opinion, says this is a major case, a major piece of legislation. This is a case in which Chevron does not apply, doesn't use the Chevron framework. Turns out the agency wins anyway, but judges decide that, not the agency. No deference is given to the agency's view. Okay, so this doctrine is pretty clearly back. This is a panel about the Clean Air Act. You'll notice I haven't mentioned it yet. The way that I came to this is through study of the Clean Air Act, in particular the Clean Power Plan. Clean Power Plan has all the hallmarks of a major questions case. There aren't a lot of major questions cases. It's kind of hard to figure out what those hallmarks are, but it has to be something about major economic impact, an issue of political significance, probably a change in agency position, or at least a new regulatory program or pullback from an existing one, and then maybe something about short or thin regulatory text or statutory text supporting it. All four of those things are present in the Clean Power Plan. So it looks fairly likely, or at least plausible, that this is going to be another major questions case, and therefore that we could, if that were true, we could really say this doctrine is back. Doesn't tell us how often to expect it being used, but it's back in some sense. It really is part of Supreme Court doctrine now. The last part of the paper, and the thing I want to focus on today, is this a good thing or a bad thing? Most scholarship that's looked at the major questions doctrine in the past has said this is a bad thing. We shouldn't have separate rules for big cases. We should have one rule for all the cases, and if it's the wrong rule, we should reject it. If it's the right rule, we should keep it. It's hard, these critics would suggest, to decide what's a major case. It seems fairly arbitrary. There's a thin line. Cass Sunstein has made a cheeky argument that Chevron, if there's a major questions doctrine, that Chevron itself should probably fall into it. It looks like a major question if you go back and look at it. And in any sense, it's probably arbitrary to draw that line. It's really hard to do that. And moreover, even if you were able to draw a line, all the things that motivate you to think Chevron is a good idea, assuming that you do, should apply even more strongly in big cases. If you think agencies are good at making certain kinds of technocratic decisions, if you think Congress meant to delegate this power in some kind of implied way, why would those things all of a sudden no longer be true for big cases with a lot of impact? If anything, you'd expect them to be more true. That's what the critics say. What this has resulted in is a dynamic where I think it's fair to summarize that if you like Chevron, you don't like the major questions doctrine, because this exception to it troubles you. Whereas if you have trouble with Chevron, if you worry about agency aggrandizement, or you think for other institutional or structural constitutional reasons we shouldn't defer to agencies, then you probably like the major questions doctrine, and to the extent that it chips away at it. My argument in the paper is there's a way to like both. Or at least to hold your nose about the major questions doctrine. The simplest version is this, which is that big cases make bad law. That judges either really want to decide big cases or face a lot of pressure to do so. You can pick either one. And when they face that pressure and do decide those cases, they're likely to do so in ways that have spillover effects to other Chevron cases. If you like Chevron, then it's important for step one to matter, for there to be some set of precedents, set of ideas about what makes a statute ambiguous or not. And if that precedential law gets corrupted or gets expanded by judges really pushing to decide these big cases, then that has damaging effects on all of the other Chevron cases. Chevron's scope gets narrowed, and in the limit case, it ultimately gets overruled. With the major questions doctrine, that doesn't happen. FDA, MCI, the cases where this doctrine came out of, those are step one cases, but they're not very good step one precedent. I'll defer to Jeff on this, but my sense is he'll agree with me. If you're working for a client on a Chevron case and your best argument, your only argument that this is a step one case is a cite to FDA, you're probably on pretty thin ground. And the reason why you're on thin ground, why that's separate from the rest of step one jurisprudence, is because of this major questions doctrine. Pulls it out, so it has very little precedential effect, at least on what is and isn't step one. Has little precedential effect on what's a Chevron case. In other words, major questions separates these big cases, keeps them from polluting the pool of precedent on step one or on any part of Chevron, and protects Chevron. So even if you think there are reasons why the major questions doctrine shouldn't be a separate rule or doesn't lead to better outcomes in the cases where it's applied, if you care about the much larger volume of everyday interstitial Chevron cases, my argument is you should at least be willing to accept the major questions doctrine in the current form, where there's 1, 2, maybe 3 cases a decade where it appears.
All right, well, that's actually given us a fair bit to talk about. But before we talk about it, we'll go on to Jonathan.
Thank you. It's a pleasure to be here and talk about this paper and some of the broader implications on federalism questions in the Clean Air Act. I should note, I co-authored my paper, Nate Stewart, who's also here. I'm the one who has to talk about it. So in environmental law, we're used to dealing with this question, or dealing with questions of cooperative federalism, and the idea that we're going to advance our environmental policy goals through a mix of reliance on both federal government and state governments. And it's well understood that cooperative federalism operates within certain parameters. One of them is you can't commandeer states. And in fact, even prior to New York and Prince, there were some cases in which the EPA had sought to commandeer states and ended up relinquishing those claims when they were told that essentially that the federal government would, or that the Solicitor General's office wasn't going to pursue that position. And so it was well understood that EPA just can't make states their vassals and say, implement this program for us. But there are lots of reasons why, as a policy matter, we don't or haven't wanted the federal government to simply do everything itself. It may not have the resources, it doesn't have the people on the ground, it doesn't have the local knowledge that is often important about dealing with the way a particular pollution control program may actually be most effective in a particular place. Particularly when you're talking about the front line of enforcement and compliance and the like, that takes a lot of boots on the ground to do. A state like Texas will do more facility inspections in a year than the EPA does nationwide. You want to have the states enlisted in a cooperative program of achieving these environmental goals. So this puts the federal government in a position, as we know, of not telling states what to do, but trying to make it worth their while. And traditionally, in most of the major environmental statutes, we have a mix of fairly traditional carrots and sticks. The carrots are, the feds will help you, we'll give you some money to help you hire more inspectors or more regulators or what have you. Maybe you'll get some of our expertise. And then also, if you don't do it, we'll do it in your place. And the assumption is not that the federal government's going to be running 50 state air pollution control programs, but that it might be running parts of some of them. And it's understood at the state level that there are reasons, all else equal, why you might prefer your local state regulators to the federal regulators. Your state regulators have local knowledge, they may understand certain political or other sensitivities in the state that might make them nicer regulators, more cooperative with the regulated community than federal regulators that are not necessarily going to be quite as responsive. One thing that's interesting about the Clean Air Act is while it adopts this framework, it also does something more. And what it does beyond that, I think, has an effect in the way the cooperative federalism dynamic actually operates in the way states and the federal government interact with one another. It does something more because while it threatens conditional preemption and while it says you don't get money to help you with your air pollution control programs if you're not cooperating and implementing, it also says that states can lose the lion's share of their federal highway funds. And for certain provisions, it also says that conditional preemption can occur not simply on the same terms as what states are being asked to do, but the same terms and then some. There are offset provisions that actually say to states, if you don't regulate, not only will we regulate, but we will regulate more stringently. So insofar as it's worse to have the feds regulate, it's not simply because the feds might not be as good at it, but because the feds are actually going to be more punitive. And that's relatively unique in environmental law, relatively unique in environmental policy, and it's something that, as we explain in our paper, is constitutionally suspect. Let me briefly sketch out why that is. Well, at least on the spending side, the case where the Supreme Court articulated the standards for conditional spending initially is a case called Dole, South Dakota versus Dole, a case involving condition on highway funds and drinking ages. And in the Dole case, Chief Justice Rehnquist, writing for the court, outlined a test where he said, we want conditional spending to satisfy 4 requirements. And if one looks at the structure of this opinion, it looks like a lot of other Rehnquist federalism era opinions, in that he's essentially condensing a whole bunch of different cases in the area and trying to provide a set of criteria to use for future analysis. So if you look at the structure of the Lopez opinion, for example, it looks a lot like the Dole opinion in the way it tries to condense what had come before. And he said there are four requirements, 2 of which really matter, and then there's a codicil which may do some work too. Has to be for the general welfare, but Congress decides that. There can't be an independent constitutional bar. That doesn't really do much work. But the opinion says that the states have to have notice of the conditions, and this is drawing on Pennhurst and other cases that talk about conditional spending as being in the nature of a contract. So states need to know what they're obligating themselves to do, and that the condition placed on the spending has to the purpose of that condition has to be related to the purpose of the money, and that you can't just find some pot of money and say we're going to hold this hostage. And then the court then says later on, oh yeah, well, you can't be coercive. And for years we've all been wondering about, is non-coercive shorthand for the 4-part test, or is it this actual 5th kind of emergency switch that you get to hit in a really extreme case? And lower courts, with one exception really in the 4th Circuit, a case involving the IDEA, lower courts generally ignored Dole or said that everything meets Dole. But then we get NFIB, and we get 7 justices saying that conditional spending went too far, and while the controlling opinion for the court by Chief Justice Roberts doesn't really go through the Dole analysis, it puts its weight very heavily on this idea of relatedness and very heavily on the idea of notice and the conditional spending being in the nature of a contract, and then talks a lot about coercion. And so I would argue, while the court doesn't say we're applying Dole, it's relying in NFIB on the very same cases that Dole is building upon and suggesting that they matter. And some key things in that case are, among other things, the court's saying, well, new Medicaid and old Medicaid, even though they're in the same portion of the U.S. Code, and even though new Medicaid is just written as amendments to old Medicaid, are actually separate programs. And so this relatedness concern is an issue because you're leveraging historical participation and reliance on one pot of money to get you to do something else. And we're very concerned about the fact that this is a change of such a nature that states may not have been aware that this was coming. So why do we think that this creates problems for the Clean Air Act? Well, if old and new Medicaid are separate programs, it's pretty clear that the Federal Highway Fund program and the Clean Air Act are separate programs. If one thing that could put your federal highway money at risk is failure to provide adequate remedies in state courts for citizen groups to challenge the adequacy of permits for stationary sources, it's hard to argue that that is somehow more related than old Medicaid and new Medicaid. In fact, they have nothing to do with each other whatsoever. And from the notice standpoint, not only do you have evolving standards or evolving requirements in the Clean Air Act administratively, its very structure in the NAAQS program is such that over time, states are being told that the standards they have to meet are different, are more stringent, and the actual measures they need to take to meet those standards are going to evolve over time. Not only can standards become more stringent, they can actually become new standards, right? We can divide particulate matter into fine, or subdivide out fine particulate matter. And so states are not on notice from anything that Congress did about what the specific standards are that they should meet. So our contention is this is why, if the court meant what it said in NFIB, which separate question, and is going to follow that, again, separate question, that the Clean Air Act would be suspect. And just to know, the Clean Air Act, the highway funds are not at the level of Medicaid funding, but there's really significant source of state funding. For the average state, they're about 3 to 4% of the total state's budget, about a third of all transportation money in a given state. And for states that have low population and large land area, the Wyomings, the Montanas, South Dakota, and so on, and you look at Medicaid money, you look at pre-NFIB Medicaid money, and you look at highway fund money, you find numbers that actually start to get really close to one another. So if there is a program that is caused into question, last point, because I know I'm running out of time, in practice, the highway fund sanctions are rarely invoked. So one may say, well, why does any of this matter? Well, it matters because what happens is the EPA says to states, you're on the clock, you have a certain amount of time in which to cure your deficiencies, or we will begin imposing sanctions, first offsets, then highway funds. And that certainly does affect the way states and the EPA negotiate over what is a suitable implementation plan under the Clean Air Act. Because while the EPA doesn't want to take the highway money away, and the states certainly don't want to lose it, the fact that there is a non-discretionary deadline at which point those funds have to be taken affects the leverage that EPA has against the states, and affects the way that the act gets implemented in purpose or in practice. I will stop there because I think I'm out of time. So thank you.
I think we'll have plenty to talk about during the. Thank you, Bill.
Thank you. Well, first, thanks to Jonathan and the organizers and George Mason for this excellent conference. Wonderful people, and it was a pleasure to read these papers. So what I'm going to do is I'm going to try to offer my own comment and comment on their papers under the rubric, what I'll call Federalism, Games, and Claims, and the Clean Power Plan. So I'm briefly going to comment on major questions in Nathan's paper, and then also conditional federal spending in Jonathan and Nate's paper. And then I'll talk briefly about how federalism games have been central to the development and battles over the Clean Power Plan. And then, all in 8 to 10 minutes, talk about how scholarship on environmental and climate federalism is sort of tested and implicated and illuminated by looking at what's happened with the Clean Power Plan. So first, on Nate's paper, I assume most of you have not had a chance to read it. It's a really good, thoughtful, nuanced paper, very thorough. He really thinks of it. It's kind of like someone looking at the facets of a crystal. He says you could look at it this way, you could understand it this way. I think he perhaps, in my view, tries to come up with sympathetic reads for the major questions doctrine that maybe sidestep a little bit the way most people see it. Most people see the major questions doctrine, I would say most Supreme Court justices see it as explicitly and overtly an anti-regulatory, having an explicitly anti-regulatory valence to it. That is, when you actually look at the way it's been used and the way it's described under its own terms. And so a question is that a good or bad thing? Nathan does a very nice job in talking about ways to kind of limit it, justify it, and explain it. But I do think that we need to think about any kind of explicit empowerment of judges to frustrate agencies, and maybe what Congress has tried to do with an overtly substantive valence to a doctrine. There's a question about that. What I liked about his paper at the end, he kind of tries to identify different facets of it and see how different major regulatory challenges have been assessed. And he says he thinks the Clean Power Plan, therefore, is a good setting to implicate the major questions doctrine. I actually think, partly drawing what he says, but maybe refashioning it some, that there's a fairly simple set of analytical steps that normally are done and are normally the reason why it's not implicated that I think should be paid attention to. So you read a statute. Does it delegate to an agency to act in an area? Does it delegate to an agency authorization to engage in rulemaking? Does it assign a discernible task so you know what they're doing? Is the agency acting in regards to that task where they've been granted turf? Fairly, is there some countervailing language or allocation concerns, such as federal concerns? And then really, I think a big issue is how tethered to a textual hook is the agency's action. And I look at Section 111D, which, although it's endlessly fascinating, I won't quote all of it to you, but if you look at the actual language of 111D, it is about as explicit a conferral of power to EPA to act in this area. Where the dispute arises is either people's unhappiness with what they see as the economic impacts of it, or the so-called regulatory tool choice, when it comes down to the final option, how they regulate it. That's a very different question. And I think that that's a setting where, when you look at the major questions doctrine cases, it doesn't really fit. And so I disagree with where he comes out saying it fits. Jonathan and Nate's paper on is the Clean Air Act unconstitutional, and their parsing of conditional federal spending is, as always with Jonathan's work, and I assume Nate's too, but I don't know Nate's work, is also thoughtful, also thorough, and really pulls together arguments to defend conditional federal spending doctrine with some teeth. Jonathan tends to have a fair-minded but sort of anti-regulatory bent, I've noticed over the years, especially when we've been on counter at congressional hearings testifying at different sides repeatedly. But his paper is really good, really thorough. I also commend it to you. I think it does a couple things that are worth note. Most people look at South Dakota versus Dole, the earlier conditional federal spending case, and then look at the Sebelius as the two big cases. And what he and his co-author do nicely is point out, no, New York versus U.S. is extraordinarily important on this language, and they do a very fair-minded read of New York versus U.S., both about the punitive use of conditional federal spending being explicitly blessed in New York versus U.S., and then similarly that within New York versus U.S. No, I guess I don't want to pull my punches for later. But in any event, I think that discussion, which in their paper, if you want to look at it, it's about page 61, where they talk about that aspect of New York versus U.S. and why that's so important, I think is absolutely correct. And I think if you actually look at a lot of the briefs in the Clean Power Plan, the people attacking it, to their detriment, did not engage on this point, because it is a substantial, important doctrinal point, and they do a very good job with that. The paper also comes out and says that conditional federal preemption, that is, regulate according to federal standards, or regulate as we would, the feds, or get out of the way, that's upheld in New York versus U.S. And the Clean Power Plan does offer that, and that is a major hurdle for challengers to the Clean Power Plan to overcome. Okay, now what about the Clean Power Plan? I said federalism games. Yeah, okay. So here I'm talking about how federalism has been part of the development and battles over the Clean Power Plan. And much as the moon is made of cheese all the way down, the Clean Power Plan is federalism all the way down. If you look at how it was developed, how it was generated, almost virtually everything about it, including battles, federalism has been absolutely central to the Clean Power Plan. Part of this is because Section 111D explicitly is about federal regulatory power and then handing over power to the states, and cross-references that make it laden with layer after layer of federalism law under the Clean Air Act. Then the big question, of course, is there some infirmity with it when you actually look fairly at the body and doctrine of law here? I think that if you look at the language of Section 111D and when it arises, there is nothing terribly unusual or extraordinary about this action. Some people say, well, why haven't they done more under this? The Clean Air Act mostly regulates so-called criteria pollutants and hazardous air pollutants. And so there have not been many instances where 111D regulation has been triggered. That doesn't make this an unusual, out of bounds assertion of regulatory power, as Jonathan and Nate talk in their paper in the UARG case, Utility Air Regulatory Group case. And so I think to look at this assertion of regulatory power is not extraordinary. And although people have not mentioned it, it's kind of important. Actually, I think you may both mention it in your papers, but in the American Electric Power case, the Supreme Court very directly said you cannot have federal common law assertion, public nuisance actions against existing power plants because EPA has power under Section 111D to regulate existing power plants. It's going to be kind of hard, especially for the DC to say, I assume Don's going to be doing like mixing up there. He has the headphones on, but if he's getting ready with the sound effects, that's fine. But I think it's going to be very hard for the D.C. Circuit, in the face of that Supreme Court language and the strong text, to say that this action is out of bounds. Also, on the federalism game, if you look at the development of the Clean Power Plan, it is explicitly built upon state innovations that have gone over the preceding years, and then in turn hands over huge flexibility to the states to come up with effective, cost-effective ways to regulate. So that's kind of part of the federalism games, but the challengers have done what I call the swank move, which is to say this is an impingement on state interests, this is an excessive assertion of authority, and therefore courts, I don't know what that is, but therefore the states, the federal government should not have deference provided to it, and so the federalism mantle is very important. If the courts see EPA as having respected federalism authority and bounds, I think EPA should be solid. If they view this as an excessive assertion of power or an undue impingement on state interests, then I think deference can go out the window, and especially the Section 112 cross-reference. If deference disappears there, then EPA could be vulnerable. Lastly, just I said, talk a little bit about federalism claims. There's a really interesting literature, which I'm sure all of you have spent a lot of time reading when you're trying to get some sleep, on cooperative federalism and environmental federalism and the interactive nature of federalism, how it works. And I've written a lot about it. Jonathan has, many people here have. And it really is a very interesting area of scholarly ferment going back now to the early 1990s. And I find interesting, if you look at the Clean Power Plan and battles over it, how virtually every single kind of assertion and counter assertion is sort of illuminated and tested by its development and the battles over it. So just one big issue is it better to have areas of complete and separate federal and state turf, as was suggested in the last panel by Mr. Parrish? And so in the Clean Air Act, you've long had an area of overlapping, concurrent, and interacting forms of interaction, and also the use of so-called floor preemption, where the states have been able to do more during a period of federal inaction or lax regulation. Clean Power Plan builds on these state innovations developed during this time of laxity, but it also builds in part on progress at the federal level that was possible because Massachusetts, under federalism, could sue the federal government. And then lastly, I just say that if you look at this one, just kind of leave it with a question, a lot of these doctrines are sort of scale-tipping doctrines on federalism, major questions, often are used with an anti-regulatory valence, and that's how they're generally discussed. And so a question is, what happens if the flip side, if an agency regulates in a way that is overtly an attempt to be cost-effective, to allow flexibility, to build on state interests, and tether their regulatory initiative closely to statutory text? Should they therefore kind of get and also I'd say that after Michigan versus EPA, explicitly pay attention to costs in a major way? Should that tip the scale the other way? That is affirmative attention in areas the court has recognized as sensitive, should that work in an agency's favor so they essentially get deference plus? And my suggestion, if you read these cases fairly, they should, but that hasn't, we'll see what happens there. But I do think it's an interesting question to ask. I'll stop there. Thanks.
Well, again, thank you. Our fourth panelist, and Don, I just want you to have a sense of the scene here. The four of us are sitting up in front of this giant screen, and you are looming over the rest of us. So
thousands of people in the audience.
That's right. So we are looking forward to hearing wisdom from on high, Don Elliott.
Well, thank you very much, Jeff. I appreciate it. It's a great pleasure to join you, even if only by electronics. I want to thank the Center for the Study of the Administrative State. I used to feel very lonely as a conservative law professor talking about these issues, and it's really great to have a critical mass of people that are engaged in a dialogue. I don't really think of us, certainly don't think of myself as a conservative, but rather as a sensible or common sense environmentalist. But I think this is a wonderful event. I want to talk first about the paper that Nathan and Jonathan did together, and I'm in general agreement with it. In fact, I can't think of anything that I disagree in it, but I just want to be careful not to endorse something that I may have missed. But in general, I think they make a really good point that there are portions of the Clean Air Act that are constitutionally suspect. I certainly don't speak for EPA after having served there about over 27 years ago, and I was part of what at the time was regarded as an occupying Republican army, so I don't necessarily, and I'm sure Jeff remembers, but I do think that the General Counsel's office was aware of the fact that there are a number of provisions of the Clean Air Act that might be applied in an unconstitutional way. My only point would be that most of these challenges would be as applied challenges and would depend on the facts and circumstances that are involved. I'm not as clear as Nathan was that highway funds necessarily wouldn't satisfy the nexus requirement. I think that would depend on the facts and circumstances and whether or not the same pollutants were involved. But I would also note that cutting off highway funds and increasing congestion would probably make a pollution problem worse. So I think EPA has been very reluctant to use that particular remedy and has tended to do federal implementation plans instead, in part because I do believe that there is, particularly under recent cases like the Sebelius case, there would be a substantial question. So let me turn to the other very interesting topic, and that is the major questions doctrine. It seems to me that perhaps the most profound thing that the Supreme Court has said recently is a question that Justice Kennedy asked, a hypothetical question that Justice Kennedy asked during the argument in the Sebelius case, the first Obamacare case. And counsel was arguing that Congress could simply amend the statute to deal with issues. This is the standard sort of Hart and Sachs argument from the 1950s that the court doesn't need to worry about issues of statutory interpretation because if they get it wrong, Congress can simply amend it. And Kennedy essentially brought down the House by saying, well, now, counsel, is that a hypothetical Congress or the Congress we actually have? And I think that's a very, very revealing comment. I think most of the members of the Supreme Court don't believe that Congress works very well to perform its traditional functions. And I think underlying the major questions issues is really a question of whether or not when Congress fails to act, the courts or the agencies or some combination of the two is going to update the law as necessary. This is really the idea that Judge Calabresi talked about in his book, Common Law for the Age of Statutes, a number of years ago, where he posited that statutes would become out of date. I call this statutory strain. I guess the title of this is Chevron and Statutory Strain. An example is a few years ago in 2013, I wrote an article which I think is one of my best articles called Why the United States Does Not Have a Renewable Energy Policy. Unfortunately, 2 or 3 years later, we now do have a renewable energy policy. It's called the Clean Power Plan. And it was not promulgated by the Department of Energy, but by EPA. I think it clearly raises questions under the statement that Justice Scalia made for the court in the UARD case, where he said, in that case, EPA's interpretation is also unreasonable because it would bring about an enormous and transformative expansion in EPA's regulatory authority without clear congressional authorization. We have a situation in which Congress has not given the Department of Energy regulatory authority to develop a binding national energy policy, and yet EPA asserts under the Clean Power Plan that it can basically do that. I think clearly under the dicta in UARG, the Clean Power Plan, at least some of the means in the Clean Power Plan, I agree with what Bill Busby said, that it's not so much the question of whether or not you can regulate these sources, but how you do it. I think under Justice Scalia's sentence in the UARG case, there certainly would be some question. But I think that Justice Scalia's statement in UARG is really confused and incorrect. I think the question of whether there's clear authorization is really separate from the question of whether or not the court thinks the interpretation is reasonable, or at least that's what I'll argue. It's very well established, I think, that the courts can fundamentally change laws that have gotten out of date. This has happened many, many times. I think of the Weinberger case in the 1960s that essentially opened up the possibility of informal rulemaking, or the interpretation in Sweet Home versus Babbitt that the Endangered Species Act can be extended to protect habitat. So there are many, many instances in which courts, and the Sebelius case itself, in which courts have taken it upon themselves to fix statutes that they see as being out of date or in strain with the current situation. And certainly we have that with regard to the climate change issues. We have a decision in Mass versus EPA that puts the burden on EPA to deal with climate change. And what remains to be seen is whether or not the courts will allow EPA to interpret statutes that don't provide, quote, clear congressional authorization to be able to deal with the problem of climate change. So I think part of the strain here is a mandate to deal with a problem, but the question of whether or not the tools, such as cap and trade programs or encouraging the substitution of renewable energy, will be allowed to be made available to deal with the problem. Now, I think it's clear that Chevron originally was not intended to allow agencies to interpret their statutes to deal with broad and new situations. Richard Lazarus has gotten into some fascinating notes by Blackmun of the conference on the Chevron decision. And in conference, when he didn't have the benefit of law clerks writing the opinion for him, Justice Stevens, who wrote the Chevron opinion, said, well, I say that when we don't understand the statute, we ought to go with the agency. And I think that's the original meaning of the Chevron decision, that in complicated statutes, when you have interstitial questions, you really ought to defer to the agency. But it's what literary critics call the intentional fallacy, to believe that the intention of the writer of the opinion necessarily defines the limits of the legal doctrine. And since we're in a law school, or at least you're in a law school named for Justice Scalia, I'll relate my one Justice Scalia story, and that is Justice Scalia told me one time that he repeatedly told Justice Stevens that Stevens didn't understand Chevron even though he wrote it. So I think he was recognizing that a doctrine can sometimes take on a life of its own. It does seem to me that although Justice Roberts is correct in observing there really isn't any jurisdiction, there really isn't a difference in administrative law between jurisdictional questions and statutory limits on statutory authority. Nonetheless, it does seem to me that one of the basic design principles behind the Constitution is that no branch of government should be able to aggrandize its own power without at least the concurrence of one other branch of government. And I think applying that design principle suggests that agencies on their own should not be able to have a major expansion of their power, or what Justice Scalia calls in UARG an enormous and transformative expansion in EPA's regulatory authority. But I think where he goes wrong is confusing the question of whether or not an enormous and transformative expansion in regulatory authority is reasonable with the question of whether or not there's clear congressional authorization for that. And I think the issue behind the major questions doctrine is the question of whether or not, if an agency interprets a statute to expand its power, are the courts willing to accept that under Chevron as reasonable? Well, with that said, I do think that at the end of the day, the Supreme Court decision on the Clean Power Plan will be one of the most important decisions, not just as a matter of environmental law, but as Jeff said, of administrative law and even constitutional law. And unfortunately, I think it depends on who the ninth justice is. I think it could go either way, depending on which way the election comes out and who the ninth vote on the Supreme Court is. And with that, I'll stop.
Well, thank you again to everyone. I want to bring us back to what I think is a very simple question, but I think it really has implications for all of these doctrines we've talked about. So we all understand the difficulty in discerning the intent of Congress. It's kind of a vague idea or a puzzling idea if you know how Congress works, because the vast majority of members of Congress have no idea what they've enacted into law. But there are people, whether you call them staffers or members of Congress, who do draft these language, who have negotiations about what it means. And so when a statute like the Clean Air Act is adopted, those people, and we'll call them Congress, have something in mind. So when a court is reviewing an agency regulation, is there a difference between really trying to discern the intention of the drafters on the one hand, trying to figure out using traditional tools of statutory construction to ascertain what Congress really meant here? Is that different from saying, has the agency, I think in Bill's words, come up with a way to tether the regulation to statutory text? Has the agency been able to construct a theory under which what they want to do is somehow related to or justified under the statutory text? Are those the same things, or are those two different things?
Go ahead. I guess just two things. One is, since we're in the school named after Justice Scalia, I think the first thing you'd say is, no, it's not intent. It's reasonable meaning, and I think that's first the point. And then I think that the way you'd answer that is maybe a hybrid, which I do think that there's a consensus. You read a statute and you want to win in the courts these days, or win before an agency. It's text, context, structure. And then perhaps you look, text, the context of the language, the structure of the statute, you make it work, and only after that you get to other indicators of something like the drafter's intent, which, even now, I'm sure as you know, probably your briefs haven't looked, but most sophisticated appellate litigators now, if they touch on that, it's a totally separate section, which says something like, and in addition, by the way, after we've looked at text, context, and structure, the legislative history is confirmatory of our exceedingly sound read. And so it seems to me that I don't know whether you're trying to find what the staffer thought. I do think that's a problem, and you don't want to do that. On the other hand, I think playing after Justice Scalia, I think he really has been instrumental in transforming statutory interpretation where it is text, context, structure, and then from that you try to figure out that the agency has the authority.
Jeff, could I add to that when it's appropriate?
Sure, go ahead. And then we'll go to Jonathan.
So I definitely agree with that. I had a very interesting experience a few years ago where I was allowed to moderate an off-the-record discussion between the justices of the Supreme Court and the justices of the European Court of Justice. And it was off the record, so I won't quote anybody, but I will say that there was a pretty broad consensus among the court that congressional intent was a legal fiction, and that what they were really trying to do was public meaning of the words. Among other things, some of the justices indicated that the intentions of individual staffers were not something that had been voted on by a majority of both houses and signed by the president, and therefore from a democratic theory standpoint, it really was the public meaning of the word. So I think that's really the prevailing ethos within the Supreme Court, and I would add, I think properly so.
Jonathan?
I mean, I think I'm certainly sympathetic to that view, and I think that's true in terms of what the court does. Let me just, two wrinkles, which I think are worth thinking about. One is that Chevron Doctrine itself is, as the court has construed it in subsequent cases, is based on the idea that Congress has delegated authority to fill gaps and resolve ambiguities even when Congress hasn't explicitly said so. It operates as a background rule that assumes delegation has occurred, and I would argue that major questions and a lot of other of the modifications to Chevron are generally best understood as trying to operationalize this understanding of delegation having occurred even though no one said. And the no one said part, I think, it creates some tension here. The other thing I would just note is Chris Walker has a paper that is very important in this regard that I'm not sure we've all figured out precisely which way it should cut, but documenting what I think many of us understood happened, but documenting it actually formally, if this occurs, that a lot of times when you have complex regulatory statutes, it's not the member of Congress that's writing it. It's not even the legislative staffer that's writing key portions. But that key portions of the relevant statutes are in fact written by agency staffers and by agency counsel. And the agency counsel are in fact writing the instructions to allow the agency to, depending on how cynical you want to be, achieve the goals that Congress wants to see achieved, or let the agency do the things that the agency would like to do. And if we understand that in a lot of these statutes, that's the provenance of the language at issue, we have to think about how that should influence the way courts view problems in that language or gaps in that language, particularly as it relates to what authority has the agency to give.
So you're not going to take debate on that one?
No, well, let me just say this. If you think that...
Otherwise, let me interrupt it, because we've had this conversation before. So here is my assertion. Back in 1970, when Section 111 was adopted, everybody involved, everybody who had a thought about Section 111, viewed it in a certain way. And I think that's absolutely clear. I think that's clear from the structure of the statute, the way it's been implemented for many years. That intention is pretty plain and simple and has absolutely nothing to do with the agency now done under Section 111D. Should that be troubling to us, or is all we care about the fact that EPA has been able to construct an argument that says we can put these words together in a way that supports what we want to do, and you should defer to us?
Let me make an analogy that I won't elaborate on, and then I'll try to make another point. So let's assume that's right, that whatever EPA is doing now, no one who drafted or voted on 111D in its form in the 70s would recognize. Even if that's true, that's probably not surprising. How many of the congressmen who voted on the Sherman Antitrust Act would recognize modern antitrust policy as, defining activity and restraint of trade, whatever the text was? That's evolved over time. It happens. There are limits on the court has set on how that evolves over time that are ultimately grounded in that text. Then, of course, Congress could revise the text in principle. This understanding evolves. It doesn't evolve in an unlimited way. It's limited by the text, far beyond what the legislators originally intended. And let me also say this, that if you think that when legislation is, the text is settled on, it's passed by both houses of the Congress, presented by the president signs it, if you think that's once it walks through that door, that the provenance of the text, whether it be the minds of the staffers, is washed away and no longer relevant, then you think the same thing should be true, Jonathan, for whoever happened to write it, the agency here. It doesn't matter if the agency wrote it, or an environmental group wrote it, or ALEC wrote it, or some random staffer wrote it. Once it's passed through that presentment and signing barrier, it becomes law, which it becomes magic in a sense. And then the court should try to interpret it, not just the text, but the context and the structure. That's my understanding of the modern understanding of statutory interpretation. The This is what I try to tell my students is, if they're writing briefs, what they want to do. That could change. It certainly wasn't always that way, but that's my best understanding of what it is.
Jeff, can you put me in the queue to get into this at some point?
Certainly. You're up.
Okay, great. Well, I don't want to take a position one way or the other on the Clean Power Plan, and I don't want my comments to be misunderstood that way. But let me just pick up on your point about 1970. I've done a lot of work on Senator Muskie and the intentions that he and his staff had in 1970 when the Clean Air Act was written. And one of the things that I found very interesting is that they didn't feel that they knew how to deal with air pollution problems. So what they did was created a number of different what they called tools or a toolbox and delegated it to the agency to use these various tools to deal with air pollution problems as our knowledge of them evolved. And so there are some provisions of the Clean Air Act, such as the imminent and substantial endangerment provisions, which have become very important under other statutes like RCRA, but really have not developed under the Clean Air Act. So I guess I would think that, and nobody knows, but my image is that if we could channel the spirit of Senator Muskie and his staffers, they would probably approve of the notion of the agency using the statutory tools that they were given to deal in creative ways with new air pollution problems that were not envisioned at the time. And I would also point out that as the Supreme Court noted in Mass versus EPA, the word climate does actually appear in the 1970 Clean Air Act as part of the definition of secondary standards. But I think it was envisioned in 1970 that EPA would have to use the various statutory tools that it was given in creative ways to deal with problems that were not fully understood or anticipated at the time.
But I don't think anybody would disagree with that, but I guess my question has to do with the definition of the statute. Because I think Section 111D was a statutory tool that had a specific meaning, and EPA has substantially changed the meaning of that. But I'm getting at it.
Well, I would agree with
Let me
that.
go on to the next.
Can I
yeah, please.
comment on that? So, Jonathan mentioned and discusses in this paper that as the ubiquitous Cass Sunstein said, that the Chevron case itself was a major questions case, and so then what do you make of it if it's being used to create an exception to it? But I also think people should go back and, if you haven't, look back at the Chevron case itself in the substance of it. The Chevron case is based on the word stationary source. EPA was given authority, it was approved in its effort to shift from a stack-by-stack approach to a facility-wide bubble to allow trading based in part on, as the Supreme Court puts in a footnote, based on economic modeling from, probably these days it would be this school, but it was mostly economists, showing how pollution trading was a way to more cost-effectively regulate. But this is based on the word stationary source with no other textual hook to justify it. In contrast, if you look at 111D, which explicitly cross-references Section 110, Section 110 is the state implementation plan provision. Explicit amendments in 1990 talk about encouraging marketable trading, marketable permits and other market-based regulation. And so what EPA has done here really tracks the statute closely. There's a much stronger textual hook for the Clean Power Plan than there was for the bubble strategy used in the case leading to, and the regulation leading to Chevron. And just as far as something else interesting to look at, in 2004, when there was this question about the line between 111 and 112, most of, not all, but most of the power sector weighed in lengthy statements to EPA saying, you, EPA, have the power under 111D to regulate via cap and trade. And then many of them went further and said, and not only that, but you should completely knock out the power of the states to do anything in this area, which would, of course, run afoul of more recent federalism cases, or at least be problematic. And so if you look at those statements, which were officially submitted, they were a strong, full-throated embrace of effectively what is the Clean Power Plan, but in a more intrusive and rigid way than ultimately embraced here. So I actually think that, again, putting aside this question of individual intent of drafters, but what the text says, text, context, structure, 111D creates a strong basis for what the Clean Power Plan does.
Well, I'm gonna try to move us because we could, as someone who spent much of the last 2 years on 111D, I have opinions about many things, but I'm going to try not to voice them. I want to go on to the next question. So, if, as Don pointed out, it is now common, or at least not uncommon, for judges to reinterpret statutes to fix problems. And the theory is, well, Congress is dysfunctional, and therefore the courts need to step in to fix those problems. But doesn't that actually undermine the role that Congress is supposed to play? And here, and again, I reveal my bias, but I'll try to do it just very quickly in a way that will generate discussion. Don and I were both involved in the last time there was a major environmental statute that was developed and passed, the 1990 Clean Air Act amendments. The first President Bush had made it a campaign promise, remarkably, that he wanted to modernize the Clean Air Act. The administration actually had a very comprehensive bill that it drafted, that it had introduced. And then for the next almost 2 years, there were senior White House officials and senior EPA officials who every day were involved in discussions with people on the Hill, with industry groups, with environmental groups, basically to try to hammer out all the compromises that were necessary to get that legislation passed. That's a model. On the other hand, if you sit in the White House and you say, you know what, I can do what I want to do without going through that effort. I can do what I want to do without doing the hard work and making the compromises and doing all that, because I know the courts believe this is an important problem, and I have a theory by which I can do what I want to do under the statute. Doesn't that really subvert what is supposed to be happening in the whole legislative system? I mean, if you're a president with that kind of authority, why do you really want to engage in Congress to do the hard work of getting legislation passed?
I certainly agree with the premise, but I'm going to make two comments on that. One is, if, to use the tool analogy, if Congress gave the agency a hammer and the agency finds nails that it hadn't been thinking about before, well, Congress gave the hammer. And so I think the question needs to be, what did Congress give the agency the power to do, not what particular thing was Congress focused about, or what particular problem did Congress think the agency was going to solve with that tool. I think that's the right way to ask the question. In terms of court-fixing statutes, I think I think it is a problem when the courts take it upon themselves to truly fix a statute, as opposed to recognize that statutory language may actually authorize more or do more than it may have originally been understood to do. And I think that the history of the Clean Air Act proves the point, right? And one of the problems when courts do this is that courts actually often don't know what they're doing. Massachusetts versus EPA is a case in point. I think it was a terrible decision. I know Bill likes it, but it's very clear that in Massachusetts versus EPA, the Supreme Court had no idea how declaring greenhouse gases to be a pollutant would affect other portions of the act. And if you look at UARG, and if you look at, in particular, the DC Circuit opinion below in UARG, the mess in that case is all because when you say greenhouse gases are pollutants and you start thinking about the stationary source provisions of the act, it's a mess, right? The EPA's, what drove EPA to try and rewrite numerical thresholds in the statute was the fact that hard numbers that Congress had written cannot be applied to greenhouse gases. So EPA had to say, well, we're going to change them, or we're going to delay implementation, which also doesn't work in a statute where the agency's hand can be forced by citizen suits, quite clearly and explicitly. You see the same thing, incidentally, in a case the DC Circuit just handed down a couple months ago, the U.S. sugar case. It's one of these 150-page per curiam opinions where each argument probably got 2 pages of briefing. And we can't expect our most judges to understand how what is done with one little argument or one part of the case or one part of the statute affects the other things. And so when they try and get beyond what the statute actually says, and do it in the name of trying to update or fix, they're likely to introduce or create more problems than they're actually solving. That doesn't mean Congress is perfect. The big problem about how you interpret 111 in the Clean Power Plan is itself evidence of the fact that Congress itself is, even in statutes that, you know, in the grand scheme of things, go through a fairly extensive process, and where there was a real effort to get things right and so on, even in that kind of statute, you are going to occasionally have mistakes. But I think the nature of those mistakes and the need to constantly keep fixing them is less likely when we leave the legislative process to do that than when we try and encourage the courts to do it.
If I can just briefly add, so let's assume that Jeff's story is true, and that in the wake of, or in a world of congressional
I
inaction.
think we can assume that safely.
Okay, well, good. I'm glad we. So, you know, Congress doesn't act. Congress seems unlikely to act at the rate it has in the past. Therefore, judges maybe openly, maybe secretly expand the range of deference that they give to agencies just to keep policy moving. You might think that's a problem, but in your argument that that's a problem, be careful that you don't say too much, because just because judges are doing that doesn't remove the ability of Congress, should it eventually choose to act, to change the rules. Congress can still do that. Judges are aggrandizing more power, they're just deferring more. And let me suggest that boundary between inaction and action is that gap is not as wide as you might think. There's a bill to strip essentially climate authority out of the Clean Air Act that has passed the House, nearly passed the Senate. Now, had it done so, of course, it would have been vetoed by the president, but that's kind of the way our system works. Like, it's not that far away. You know, yeah, you need 60 votes. Yeah, you probably need 66 or whatever a veto-proof majority is. But we're not that far away from that world. So if the agency really goes crazy and somehow judges agree with it, then we're suddenly in a world where, you know, not only Joe Manchin, but like a bunch of other Democrats might consider voting for that, or we have an election that changes the idea of what we want. And Congress has that power, no matter how much games courts and judges play with deference.
Yeah, could I just add something to that when it's appropriate?
Yeah, let's hear from Bill first.
Okay. That's working. Okay. Two things. As far as congressional correction, I actually was looking into this. I think since 2011, there have been 237 bills introduced pertaining to federal regulatory authority over climate, and only a small number of them were affirming or, you know, expanding on power. Most were to different ways trying to take away power. So it's a very active, very affirmant. And the other is just something I think is important, which is if there's a statutory problem, do you want courts to fix it? Do you want agencies to fix it, or no one to fix it? Or to at least take steps to fix it? And I guess the one thing that's pretty clear is no generalist court will have a comprehensive understanding of a statute, the regulatory infrastructure that goes with it, the interest groups that are dependent on it, and the law that's developed over time. That is, a generalist court can't. It just simply can't. So if there is to be an institution to at least make partial steps to make a statute work, agencies, because of the quasi-democratic process that's highly interactive, rulemaking and other informal interactions that go on all the time, they'll be sensitive to it. Now, whether they overreach is another question, and actually, I think there's something to what Jeff said. You know, if a statute is clunky and doesn't grant power, then it should be enforced, and sometimes it has to be Congress that will fix it. But as Jonathan said, if the agency's been handed a hammer, it's been handed a task explicitly, I think all agencies going back to the earliest, well before the 20th century, will over time adjust what they do and try to make the law work.
Don.
Yeah, I just want to pick up on a couple of points that others have made. First of all, I think Jeff raises some really important and difficult issues, and I don't want to be misperceived as saying they're at all easy. My idea that we need to sort of reduplicate the constitutional structure by having at least the courts be prepared to sign off on major expansions of agency power. And that's been dismissed by Richard Epstein as thin gruel or the Constitution light, and I have a lot of respect for Richard, and I think these are difficult problems, and I think it certainly would be better, Jeff, if Congress were more active on some of these issues than it has been, and that we could bring back the period like the 1990s, which clearly is Congress performing the role that the framers intended for it. I do think that quote from Justice Kennedy that I began with reflects the perception of the Supreme Court that they need to step in and deal with things. And I would just underline the point about elections. If you look at Donald Trump's May 26th policy statement on energy policy, I think he's very, very clear that the Clean Power Plan will go away. At least he will propose to have it go away. I think he'll find out that he, under the State Farm motor vehicles case, he's going to have to go through the notice and comment process and judicial review to get rid of it. But depending on his nominee to the Supreme Court, something like the Clean Power Plan might very well go down. So I think elections are an important check on agency power, particularly with regard to these major questions, because they are still responsive to the president. Now, as a practical matter, agencies are really quite independent on a lot of the smaller or more subsidiary questions. But I do think, as our experience shows, Jeff was my White House minder when I was general counsel of EPA, and I think that was a good thing. We were not really independent. Jeff and the White House were paying a lot of attention to what we did, and I think that's appropriate. So I would just say, yes, it would be better if Congress was more actively involved in making laws, but I think there's a reality and a perception that a lot of this is going to have to be done by agencies, and I think having the courts and the executive and the president as checks on assertion of agency power is about as far as we can go in the current situation.
Yeah, we're running out of time. I just wanted to see if everybody would make a final comment, and I know it's difficult to see if you can limit it to a couple of minutes at the most.
Okay, I'll just, instead of trying to sum up, let me try to correct or respond to one thing I've heard, which is that the major questions doctrine and some of these other things that we've heard about are anti-agency, anti-regulatory, and particularly that they're aimed at preventing agency aggrandizement. That happens sometimes, but it's not always. That's not a core part of what these doctrines are, especially with major questions. Major questions can be used, just because major questions doctrine is invoked doesn't mean the agency loses. Well, and just because the doctrine is invoked doesn't necessarily mean that the problem, the thing that's major about the case is the agency regulating something it didn't regulate before. In MCI, the agency was pulling back from regulation, and that was a significant move that was determined by major questions. So if you like deregulation, you don't like agencies, this tool can be used against you too. It operates in both directions.
Like, it's two things. One is, actually, I think if an agency on its own deregulates, that's an assertion of regulatory power. It's not an imposition of a regulatory burden, but for an agency to, and one thing that Nathan's paper does very well is he points out that kind of changing the magnitude or direction of regulation is probably more important than just the imposition of a burden. So I think that's a good point. And then the only thing I'd say, just as I didn't get to that I think is interesting for those of you who are interested in federalism, the Clean Power Plan has one really interesting attribute, which if you look at it, people haven't perhaps noticed as much, which is that the way it's structured is it definitely incentivizes the states to take over the program, but it also gives the states vast power to do so in many different flexible ways. And there's kind of an interesting, it's really the way federalism works. It's interesting. Federal power is supreme, but states under both floor preemption and plenary power have a great deal of authority to act in different innovative ways that the federal government cannot itself do. And so it's an interesting aspect of the Clean Power Plan, how it kind of harnesses this different sort of grants of power to say, this is where the standard called best BSER, what would be required, but how you do it, you have vast latitude to act, and particularly the states can act in ways the federal government cannot act directly, which I think is an interesting twist.
If their state legislatures choose to give them that.
Yeah.
Let me say a couple of things just quickly about the Clean Power Plan and how our discussion relates to that. One is I do think the Clean Power Plan fits very squarely into the major questions doctrine, and I agree with Nathan. That doesn't mean that the agency's position loses. It means that the court has to answer the question, not the agency. And I think one aspect of the Clean Power Plan that highlights this is not merely the magnitude and whatever else, but the fact that one of the questions at least is what text is in fact in Section 111. And even if one takes the view that Justice Kagan articulated in a recent case, that intra-statutory conflicts are ambiguities for Chevron purposes, it's still a step further to say that a question about what Congress actually enacted when it simultaneously enacts two revisions to the same pre-existing portion of U.S. Code is also a Chevron question, because that starts to look like Congress actually delegating to the agency not interpret this and implement this, but delegating to the agency, tell us what we actually did. And so I think that has to, if there's a major question doctrine, I think there has to be a major question. Again, that doesn't mean the agency loses. It just means that, as in King versus Burwell, that it's a question that is not one that an administrative agency can exercise. On the federalism point, really quickly, a lot of federalism arguments in the Clean Power Plan. Bill and I agree that the mere fact that federal regulation will be less pleasant than state regulation under the Clean Power Plan is itself not the source of not a source of concern or legal problem for the plan. That is to say, the court has approved that in New York, it has approved that in other contexts. There are all sorts of reasons why conditional preemption inherently works that way. But there are questions about the way in which that manifests itself, not really the underlying major question about what the statute means, but to say that states can have more power or more tools inherently in their toolbox to meet the federal goal, I think cuts both ways. Because what the federal government is essentially saying to states is use tools that we've never been given to meet our goal. And there's reason to believe that the EPA wouldn't be trying to do this if states were also constrained to the same set of tools that the EPA was. Even if for no other reason than politically, EPA would understand that the number of Democrats in the Senate that would be against their doing this would increase dramatically if one of the things they couldn't say to states is, we'll give you credit for doing all sorts of things that we can't do. Again, I'm not saying this is necessarily a fatal argument, but I do think it cuts in two directions in this context. There are cases like the cross-state air pollution case where I think the court did seem to suggest that if the EPA is trying to regulate in a more flexible or more economical manner, it is going to be given more leeway with the text. I think that's one way to read the court's majority opinion in the cross-state air pollution case. But given the federalism concerns here, it's not clear to me that that's necessarily the way the courts would apply it.
Don.
I will be uncharacteristically brief. I thought I had nothing to say, but I do find I have something to say, and that is, I agree with Jeff that the question with regard to the Clean Power Plan is really whether or not the tools have been granted to EPA. I think that I want to agree with that and associate myself with that statement. And the only caveat I would add is I really think that there are a lot of different tools that are used in the Clean Power Plan, and it's not all of one piece. And one could think that some portions of it are non-controversial and other portions are controversial. So I'll just leave it with that.
All right, well, thank you. On behalf of the audience, I would just like to say how much I've enjoyed this, and I'm sorry we don't have a little bit more time, but thank you very much for your papers and for being here today.